Good morning everyone, and welcome to this morning's seminar on lease negotiation tips for landlords and tenants. Today is Thursday the 27th of January 2022. I'm Joanne Perritt and I'm the head of the real estate team here at Meyerson. What we'd like to do this morning is a little bit different to our normal seminars, but we hope that you find it interesting and engaging. We sometimes hear people saying, oh, a lease is a lease. Don't solicitors just print off a standard document and fill in the gaps? So we wanted to bring to life the very different views and concerns a landlord and a tenant have, and to highlight how things can change in the negotiation process. We also want to demonstrate how important it is to really think about these issues right from the start of the landlord and tenant relationship, to really sort of try and foresee any problems which might arise and how these should be dealt with. So that's whether you're the landlord or the tenant, or you're a professional advising either party. The terms of leases have been under the spotlight a lot over the last few years. Obviously the pandemic hit, our daily lives and business practices were turned upside down literally overnight. I think the fallout from this is going to last for decades, and I think it has certainly changed how people look at their buildings and also their leases for the longer term. So leases were dusted off and they were reviewed in detail as landlords and tenants tried to see how these constantly changing times could be navigated using the tools currently available to them. I think it's fair to say a lot of landlords and tenants will be considering the wording of their leases much more carefully across the board in future. Landlords will obviously want to make sure they stay competitive in terms of attracting and retaining tenants, but they'll also want to try and protect their position as much as possible, where there's a threat of a further COVID lockdown or perhaps even a pandemic of a different nature which might hit us in the future. Tenants, on the other hand, they're very much aware now of the damage which can be done to their businesses by something totally unforeseen. They'll be much more cautious about what they agree to sign up to and for how long they are prepared to commit themselves. So I'm joined this morning by two of our associates, Charlotte Hook and Cindy Bishop, and they're going to play the part of the solicitors acting for a landlord and a tenant in a lease negotiation. We want to bring the process to life and to put things into context for you. So we'll be taking you through 5 topics today, all of which have been of particular relevance over the last year or two, whether because of the pandemic or just changes in the law generally. So we will start with rent suspension, then we'll move through break clauses, keep open provisions, rates and taxes, and finally we'll have a look at the hot topic of VAT and dilapidations. So the first clause our representatives are going to discuss this morning is a rent suspension clause. All leases should contain a clause in the insurance provisions to suspend the tenant paying rent in the event there is damage to the property or it is destroyed. The tenant's representative will make some amendments to this clause, and they will also bring in a COVID rent suspension provision.
So I've included a standard rent suspension clause in the lease. This suspends payment of the annual rent when there's been damage or destruction to the property and the tenant can't occupy or use it. My client will take out loss of rent insurance to cover that period, and the tenant will pay the premium for that insurance. The rent won't be suspended, however, if the tenant has done anything to invalidate the insurance policy. The tenant will be able to give notice to terminate the lease if my client hasn't reinstated the property at the end of the rent suspension period, and that period is 3 years from the date of the damage, as that's the period that the insurance policy covers.
Okay, we need to amend the rent suspension clause so that it applies not only to the annual rent but also to the service charge and insurance rent. And that's because A, the service charge may include expenses which may still be incurred even if the property is damaged. For example, undamaged common parts may still need to be maintained. And B, my client does not wish to pay the insurance if they're not occupying the property. We need the rent suspension to apply if there is damage to the common parts of the building, even if the property itself is fit for occupation and use. And that's because customers and suppliers may not be able to get to the property. So the rent suspension should apply if there is damage to the property and the common parts. We also need to consider damage caused by uninsured risks, and those are risks that the landlord is not insured or cannot insure. My client needs some protection in the event the damage has been caused by uninsured risks, so the rent suspension and termination clause should apply if there is damage that has been caused by uninsured risks and insured risks. Additionally, we want to incorporate a pandemic rent suspension clause to suspend the payment of rent when there is a lockdown. And this would be triggered when the tenant is prohibited, prevented or restricted from trading from the property as a result of a pandemic.
Okay, I'll accept that the service charge can be suspended as well as the annual rent on the condition that we make sure that my client's insurance policy covers loss of service charge, and also that your client pays a higher premium for that policy. I'm not going to accept suspension of the insurance rent, however, as the tenant would have the benefit of the policy and the landlord shouldn't be expected to pay the premium themselves. Damage to the common parts which prevents access to the property is a fair point, so I'll accept that. But as with damage to the property, the rent won't be suspended if damage to the common parts has been caused by the tenant and it affects the landlord's insurance. I appreciate your addition about uninsured risks, and this is more or less a standard market clause, so I'll accept the inclusion of that. However, I want to add further provisions to state that if there's been damage by an uninsured risk, the landlord has the option to give notice to terminate the lease within the 12 months of that damage. On the pandemic rent suspension clause, I understand that rent should be suspended if the tenant can't operate fully at the property, but not if they're just restricted in how they can trade. For example, if the tenant was a stationery shop and they were restricted from selling greetings cards, but they can otherwise operate a normal business, then they should still have to pay the rent. The suspension should only apply if the tenant has to fully close up and can't operate at all. For clarity, this is only suspension of the rent and it's not a write-off. We need to be able to recover the rent after the lockdown period ends. It's very difficult for landlords to get insurance to cover loss of rent for a lockdown, and even if they can get the insurance, the premium is prohibitively high.
And I do appreciate that, but what if my client can't pay it all back? That rent should be written off.
We're just not able to agree to that in the lease, and the government supports our position. So it may be that at the relevant time, our clients negotiate a rent repayment plan or they write off some of the rent, but we can't say at the moment what they'll agree to, so we're not going to include a write-off in the lease.
Thank you both. Obviously, the last couple of years has been a testing time for landlords and tenants, and they're going to be substantial arrears to work themselves out over time. How have you both found it in practice? What sort of options are landlords and tenants going for to come to an agreement on COVID arrears, or are people electing to sort of kick the can down the road until the end of the sort of rent suspension period?
Well, we've seen a few variations, and to be honest, it's just dependent on the bargaining position of the landlord and the tenant and the circumstances of the transaction at the time. We found that some landlords are sympathetic for their small tenants who have suffered a loss of ability to trade during the pandemic, and it's caused real damage to their business. And we've seen landlords of tenants who are big retailers who are less sympathetic because those retailers, they may just choose not to pay the rent even though they can actually afford to do so.
Yeah.
Yes, and landlords at the moment, obviously, they're prohibited from doing anything about pandemic rent arrears. But we're expecting that to come to an end in the end of March. At that point, we're then expecting landlords to consider their options about unpaid rent arrears, so there'll be a lot of movement later down the line.
Yeah, I think our litigation team are thinking that they might get quite busy at that point. In summary then, from the tenant's point of view, it's important for the clause to cover service charge as well as the annual rent, and also that the clause does apply where the damage is to the common parts. COVID or pandemic rent suspension clauses are becoming more of the norm, but they're not a given and there's no standard industry wording at this point. It's important that agents and tenants agree with the landlord that a pandemic rent suspension clause will be included when the heads of terms are being negotiated. It's more difficult to get the landlord to agree to these clauses if they're not in the heads of terms. However, landlords must be aware that if they don't accept this provision, it might have a negative effect on any rent review. It's becoming more standard for leases to include a clause like this, therefore the market will expect it. A pandemic rent suspension clause only suspends payment of the annual rent and possibly service charge It doesn't automatically write it off, and the tenant must still pay the rent for that period when the suspension ends. I think that's really where all the negotiation is going to come in, and the arbitration process will be key to these matters being resolved over time. The next clause our representatives are going to consider is a break clause. These are fairly standard in leases these days, especially if the term of the lease is for more than 5 years. The most common notice period for a break is at least 6 months, but the parties could agree a longer or a shorter period. You sometimes also see a rolling break as opposed to a fixed date. Whether the lease is going to include a break clause is something that is negotiated with the heads of terms, but sometimes the conditions for the break are left to the lawyers to negotiate. It is of course also possible for a landlord to have a break option. We won't look at that in detail today, but these are often required where the landlord potentially wants to redevelop the property or to take it back for their own use at some point during the term.
So we've agreed in the heads of terms that there's going to be a break clause. The conditions for the tenant to exercise the break are that the tenant must have paid all sums due under the lease in cleared funds. Secondly, they must provide vacant possession. And thirdly, there has to be no subsisting breaches of the repair covenants in the lease.
Right, well, taking each of those conditions in turn. The first condition, paying all sums due under the lease would not be possible if there is a terminal dilapidations liability which only crystallises on yielding up. And therefore I want to limit this condition so that my client is only required to pay the annual rent up to date. For the second condition, it's too onerous to provide vacant possession. That means that my client could effectively be in breach of that condition if they leave a small item accidentally at the property, like a chair, and that would prevent them from being able to exercise the break. We need to lower that benchmark so that my client can satisfy it. A tenant should only be required to vacate the property and leave no one in occupation. And that's generally the standard position and widely accepted by landlords. For the third condition, no subsisting breaches of repair covenants is also too onerous and should be removed. This means that any breach of the repairing covenants, no matter how minute, would prevent my client from exercising the break, and that's just not acceptable. The landlord has its claim for dilapidations if there are any breaches for this condition, so it will need to be deleted.
Okay, for the first condition, I'm going to add that service charge and insurance rent have to be paid as well as annual rent. If the tenant wants to exercise the break, then they have to pay those sums due under the lease. I can accept your proposal on the second condition, however, that instead of vacant possession, it will just be the tenant vacating the property and leaving no one in occupation. I don't agree with your deletion of the condition for no subsisting breaches of the repairing covenants, however. My client wants to be in a position to grant a lease to a new tenant as soon as your client has vacated after the break date. The landlord doesn't want to have to spend time undertaking dilapidations works to the property and then pursuing the tenant for a dilapidations claim where the lease is ending because they've exercised the break.
If the landlord is absolutely adamant that that must remain in the lease, then we need to limit that so that it only applies to material breaches. And that means any minor breaches will not prevent my client from exercising the break. There should also be a provision where any advance payments of the rent and insurance rent and any VAT on those paid for the period after the break should be refunded to my client. And this is market standard and shouldn't be an issue for your client.
Yes, I can accept those.
Thank you both. So what about pandemic rent arrears where the landlord has agreed either to waive some of the rent or to delay its payment? What happens then?
So it really just depends on what's been agreed between the parties, whether or not they've been formally waived or whether it's just a time to pay agreement that doesn't have legal effect. In those circumstances, the tenant must make sure that they've paid all arrears up to the break date. Otherwise, the landlord could argue that the break is ineffective. And to be honest, it's not straightforward. So if you're coming up to a break date, whether you're landlord or tenant, you should speak to your solicitor, especially when COVID rent arrears are involved.
So the conditions and break clauses are very important, as if they are too onerous, the tenant might not be able to exercise the break and they may be tied into the lease for the rest of the term. Obviously, the tenant isn't automatically entitled to a break, so if the landlord is minded to offer one, then it can really dictate what conditions it wants to attach to it, subject to negotiation, of course. The material breach of repair condition is one which landlords do tend to concede depending on the kind of property involved and the state of the market. Landlords do always have the terminal dilapidations claim to fall back on, which is a point made by the tenant's representative. That isn't lost by the break having been exercised. It's important to note that tenants who are in arrears due to the pandemic and who've reached instalment payment agreements with landlords or who secure arbitration determinations will not be able to exercise breaks where payment of the annual rent at the break date is a condition, unless they've cleared all the arrears or the lease has been officially varied to amend the rental payment obligations. The instalment payment arrangements or arbitration determinations relate to time for payment of arrears, but they don't automatically alter the primary rent payment obligations under the lease. So moving on, our representatives are now going to consider a keep open clause. We don't often see these in leases where the property is a standalone unit, but they are common where the property is part of a larger estate or shopping centre, and the use is usually retail or hospitality.
So in this matter, we're dealing with a lease of a retail unit in a shopping centre. So my client requires a keep open covenant to oblige the tenant to keep the property open during certain hours, and they have this clause in other leases on the estate. This is to ensure that footfall is maintained and there's no empty shops where there doesn't need to be. The only exceptions to the tenant keeping the property open are during any period of repair and refurbishment or for any staff training.
That's all good prior to COVID, but the situation's changed now, and the keep open clause shouldn't apply in the event there is a lockdown. Even if my client is classed as an essential retailer who can still operate, they shouldn't be obliged to stay open if it's not cost effective for them to do so. For all we know, the shopping centre could be deserted during a pandemic.
Okay, I'll accept your position in principle, so we can include a lockdown exception. However, just as it was for the pandemic rent suspension clause, my client doesn't want the lockdown exception to kick in when the tenant's not forced to close and they can actually still trade. My client doesn't want tenants to close up just because it's not cost effective for them to do so. So I'm going to remove the reference to restricted from your suggested wording. The exception will only apply when the tenant is prohibited from operating in full.
Thank you. So how has this been working in practice? Have you seen different stances being taken by different landlords depending on the type of premises, for example?
Yes, so I had an interesting one recently where we were acting for a tenant client who runs a chain of vet surgeries, which are an integral part of the commercial areas to some new build developments. So the landlord of one particular unit argued that it was very unlikely that our client would have to close up fully if there was another pandemic or a lockdown, because they could still continue to do emergency care. Right. So they resisted us adding in an exception to the keep open clause for this reason. We successfully argued against that, however, and they did accept our position on the basis that we had to concede on the COVID rent suspension clause. They wouldn't accept one at all.
Right. In summary then, a landlord will usually accept that there is an exception to the keep open obligation if the tenant is obliged to close because of a lockdown. The wording of the exception is important, however, and that was shown by the recent case of W.H. Smith and Commerce. In this instance, the shop had a post office, which meant that the store was not forced to close, and the keep open covenant applied despite the fact that sales were down over 90%. A positive obligation to keep open will give the landlord a right to damages or forfeiture if the tenant's in breach, but it will not give the landlord a right to get an injunction to force the tenant to remain open and to trade. This is an evolving area in which a market consensus between landlord and tenant doesn't seem to have emerged as yet. Moving on again, the representatives are next going to discuss a standard clause relating to the payment of rates and taxes, which includes business rates.
So as usual, we want the tenant to be liable to pay rates and taxes due for this property during the term of the lease. We also want to stop the tenant from applying for a revaluation of the premises for business rates purposes, because this might have an impact on the other units in the estate that my client owns, and also its ability to let this property in the future. In addition, if the tenant claims relief from business rates during the term, even if that's in breach of a clause in the lease prohibiting them from doing this, then it might prevent my client from obtaining relief after the lease has ended. So we want a clause to oblige the tenant to compensate the landlord for any relief that it loses after the end of the term because it's been awarded to the tenant.
Yes, I accept that the tenant is usually liable for all rates and taxes relating to their use and occupation of the property during the term. However, they shouldn't be liable for any taxes payable by the landlord if they sell or dispose of their interests in the premises, or in respect of any taxes, except for VAT, that are payable by the landlord by reason of receipt of rents due under this lease or superior lease. I don't agree that the tenant should be prohibited from applying for a revaluation of the property for business rates, or should have to compensate the landlord for any loss of rating relief. Firstly, my client needs the ability to apply for a revaluation of business rates, as we expect those to increase after April next year. And the reasoning behind that is because during a recent Treasury review on business rates, which was published alongside the last budget, it suggested ministers are intending to keep the legal requirement for each business rates revaluation to be revenue neutral to the Treasury. So under this rule, if rateable values fall overall, then the multiplier, the factor used to convert those values into a yearly payable amount, must rise to preserve the government's tax intake. Secondly, if the tenant has to pay the business rates, then they should be capable of benefiting from any relief that's available to them.
I don't agree with your point about business rates relief, as the tenant should still compensate the landlord for any relief that it loses after the end of the term because it's been given to the tenant. So that's my final position on that point. However, I can understand your other point about revaluing for business rates, but my client will still want to prevent the tenant from applying for this, where it might have an impact on other properties that they own or its ability to let this one to a new tenant. That's because if the tenant applies for a revaluation of this premises, then the landlord's other units in the estate will likely have to be revalued as well, which obviously the landlord wants to avoid. As a compromise, I can suggest that the tenant will have the ability to apply for a revaluation, but they need the landlord's consent to this first.
I can accept that compromise, but that's provided that the landlord's consent is not unreasonably withheld or delayed.
The tenant's arguments are sound. It should only be liable for rates and taxes arising from its occupation and use of the premises. And if they're paying the business rates, then really they should be able to apply for revaluation. In practice, landlords typically concede this last point, particularly if the lease term is short. Business rates have been frozen until 2023, but after that they will be reassessed for the first time since 2017. The last Treasury review suggested that there's no intention of ending the requirement that each revaluation must be revenue neutral to the Treasury. Therefore, it's likely that business rates will actually go up to maintain the Treasury's revenue neutral stance. It's therefore vital for tenants that they have the ability to revalue. So the final point our representatives are going to consider today is a provision relating to VAT and whether this applies to a payment for terminal dilapidations.
So I've included a clause in the lease to state that a party to the lease has to pay VAT in respect of all taxable supplies, including but not limited to dilapidations payments made during the term of the lease or after it's ended.
That's not acceptable because VAT should not be charged on terminal dilapidations. As you'll be aware, there's no VAT liability on damages, and claims for dilapidations are damages for breach of the obligation to yield up the property in repair. Like any other damages payment, VAT should not attach. So the landlord is effectively trying to inflate their damages settlement by trying to include this on the dilapidations payment.
I can understand your argument, but the treatment of VAT on dilapidations payments isn't actually certain at the moment. Historically, yes, HMRC did treat dilapidations payments as representing claims for damages and therefore outside the scope of VAT, like you said. However, HMRC have indicated that their view on compensation payments may change, and until they issue revised guidance, then the landlord wants to err on the side of caution.
I note your comments and I'll accept the position, but only on the condition that VAT becomes payable if it is actually chargeable and only on receipt of a valid VAT invoice.
Yes, that's a fair compromise. I'll accept that.
In this scenario, the landlord and tenant are both right. The issue of VAT on dilapidations payments is in a state of flux, and HMRC have issued conflicting guidance in the last few years. In their latest draft guidance, HMRC have said that dilapidation payments are normally outside the scope of VAT. HMRC has also said we may depart from that view if in individual cases we found evidence of value shifting from rent to dilapidation payment to avoid accounting for VAT. Their final position on dilapidation payments is yet to be published. Whilst lawyers can draft the clause to cover VAT on terminal dilapidations if it is a taxable supply, what really matters is how the terminal dilapidations claim is settled, as opposed to how the lease is drafted. Pending formal clarification and updated guidance from HMRC on the treatment of dilapidation settlements, landlords agreeing dilapidation payments under existing leases should recite the clause repairing obligations and note that the tenant is in breach of those obligations in the lease, and provide that the dilapidations payment is in respect of dilapidations and that the tenant is released from all of its liabilities for the repairing obligations under the lease. If this isn't possible, the document should make it clear that the payment is made for the breach of the tenant's repairing covenant and not, for example, for rent arrears, assuming that, of course, that this is the case. The landlord should, if possible, ensure that the payment is expressed as exclusive of VAT as a long-stop protection against a finding that the payment is actually subject to VAT. Just to wrap things up this morning, it's clear that the landlord and tenant relationship is now in a state of flux more than perhaps at any other time in recent history. It's incredibly important that both landlords and tenants are well advised on the potential risks involved in proposed terms. What we've covered today certainly isn't an exhaustive list of issues, and we will be looking at further landlord and tenant issues in future seminars. For example, the impact of sustainability concerns and environmental, social and governance issues is something which is going to be a huge focus for the built environment over the coming years. Thank you for joining us today. Please do get in touch if you have any topics you would like us to cover in future seminars, or if you have any queries at all on anything we have discussed today. You can call us on 0161 941 4000 or email us on lawyers@meyerson.co.uk. You can also watch this webinar again by visiting the Meyerson YouTube channel, and you can find it on our website. We're hoping to be back to having a hybrid event for our next seminar, so you can come and join us for breakfast in person now that restrictions are being relaxed again. Details of that will be circulated shortly. Thank you again for your support, and we hope to see you soon. Have a good day.